Welcome to Thomas Houston Associates overview of everything you need to know about pay equity. Today we will cover equal pay, employers' responsibilities to ensure non-discrimination in pay, and pay equity analyses. Whether you're a current Thomas Houston Associates client, a new federal contractor, or simply an employer looking to learn more about pay equity, welcome to the seminar. Thomas Houston Associates' proprietary pay equity reports lend themselves to a variety of pay equity analyses. We hope you find the products detailed herein helpful to you as you move forward in this area. For over 40 years, Thomas Houston Associates has been a leader in human resources consulting. Whether it be ensuring equal employment opportunity, affirmative action, or non-discrimination throughout all employment practices, Thomas Houston Associates has been here for you. What is equal pay? It's important to know from the very start, equal pay was never intended to be exactly equal. The Equal Pay Act of 1963 is administered by the Equal Employment Opportunity Commission, or EEOC. It is largely complaint-driven by individual complainants and not class actions. Under the Equal Pay Act, men and women must be paid equally for equal work. For the work to be deemed equal, the job, not the job title, must be substantially similar, require similar skill, effort, responsibility, performed in similar working conditions, and be similarly complex or difficult. Virtually all employers are covered by the mandates of the Equal Pay Act. While men and women are to be paid equally in these situations, there are some exceptions. Men and women must be paid equally except where the payment is a result of a seniority system, a merit or performance-based system, a system which measures the earnings by quantity or quality of production, how much you produce, for example, or a differential based on any other factor other than sex. It is this fourth issue, a differential based on other factors other than one's sex or gender, is where the most concern lies. While it is clear seniority, merit, performance, and productivity are lawful factors that can help explain the wage differential between men and women, is experience a lawful factor? If so, is it the amount of experience, the type of experience, the quality of the experience, and where is this experience documented? Is education a lawful factor? Is it the type of education, where the education took place? All of these issues can help explain the differences in pay between men and women, but they also can be in dispute. One of the landmark Equal Employment Opportunity Commission Equal Pay Act cases was the EEOC versus Morgan Stanley on behalf of Allison Schieffelin. This started as an individual complaint, but grew into a class action on behalf of 340 female employees. It was settled before the jury was even seated. It amounted to $54 million, with $12 million going directly to Ms. Schieffelin, who was pivotal to the case, as she was able to produce a host of information over a period of time. It centered on pay issues, promotional issues, and the culture that took place at Morgan Stanley during that time. So what starts out as an individual complaint can grow into a class action, where more are brought in who have similar issues with an employer. So we've discussed the Equal Pay Act and the mandate that men and women be paid equally, but there are other laws and regulations that prohibit compensation discrimination on behalf of race, color, national origin, religion, disability status, and age as well. Now you may be asking yourself, where do I even start? Well, for many small and mid-sized employers, a title-by-title or cohort approach to compensation non-discrimination may suffice. An example here, all of these are senior executives or officials and managers, and only 2 have the exact same title of Director of Operations. Now, assuming they are the exact same job, I would review to make sure there were lawful reasons why the male, who you see is a relatively newer hire, is paid more than the female, who not only has more seniority with the company, but also more time in the role. This is another example of the cohort or title-by-title approach using White House staff payroll. Each year, the White House has to report to the U.S. Congress the salaries of its employees. so it's public data on about 450 employees. There are about 40 employees in the title Associate Director, of whom some are displayed here. In the left-hand column, if the traditionally female names are female employees and the traditionally male names are male employees, the males are at the higher end of the pay scale in the title Associate Director. But to ensure non-discrimination in title, assuming that the work is similar or substantially equal, we would have to pull the data on all of the associate directors to make sure there are lawful rationales for these pay differences. For Thomas Houston Associates clients, we have performed this for you on a systemic basis for years with your affirmative action program plan. Thomas Houston Associates offers a series of pay equity reports. The first I'd like to discuss is the base pay report. In the base pay report, there is a summary page comparing male and female salaries and the dollar differential between the two groups and whether it is statistically significant. Following this male-female report is a detailed person-by-person listing of all within the title. This listing is rank ordered, typically by seniority or position date, so that the compensation on an employee level can be reviewed quickly. This report is followed by a summary report of minorities versus non-minority average pay, and whether these differences are large enough to be found statistically significant as well. This too is followed by an employee level detail report. The third part of the base pay report is a comparison of average salaries by racial or ethnic subgroups. And for those employers utilizing a salary grade compensation system, there is a fourth section that lists all the employees whose salary fall below the minimum of their salary grade or above the maximum of their salary grade. Outliers, if you will. For Thomas Houston Associates clients, you receive this on an annual basis with your AAP package. Reviewing these reports and identifying the differentials by title and whether they are statistically significant can become quite cumbersome, though, for large employers. I'm very pleased to announce a new Thomas Houston Associates product that is a top-line report for employers with multiple locations or large workforces that pulls to the top, calls to your attention any title or role that has a statistically significant average wage differential by race or gender. Before moving on to Thomas Houston Associates' other pay equity products, I'd like to speak with you just a minute about range outliers. Those employees whose salaries fall below the minimum of the range or above the maximum of the range for their job. These are often the same individuals whose salaries cause there to be a statistically significant differential by race or gender. I encourage employers to review all outliers, but especially those below the minimum of their range. For often, these employees are so far below the range minimum, they may not be able to move into the range using the standard merit budget, and it may require another infusion of cash to be able to bring them into their proper salary grade range. I've talked a little bit about the Equal Pay Act of 1963 and the legal requirements to ensure non-discrimination in employment, specifically compensation. I'd like to turn our attention now to fair pay, paycheck fairness, and pay equity. Fair pay is not a new concept. It first reared its head in the 1990s in the Worker Paycheck Fairness Act. Currently, there is a Fair Pay Act in the U.S. Congress that has yet to pass. This Fair Pay Act would expand the Equal Pay Act to include comparisons by equivalent or comparable work. It has punitive and compensatory damages, and among other things, prohibits retaliation and has increased record keeping. Also up in the U.S. Congress, but has not passed, is the Paycheck Fairness Act. It too would amend the Equal Pay Act of 1963. It calls for a study of pay data of employers' pay. It would ask the EEOC to issue regulations within 18 months that employers must submit pay data to the EEOC. It changes class actions from opt-in to opt-out. And it would allow plaintiffs to recover compensatory and punitive damages as well. It also strengthens or tightens that fourth factor in the Equal Pay Act of any other difference other than sex. Now, let's talk about pay equity. While there's a lot of buzz about the term pay equity, there is no one common, consistent definition of what pay equity is. We at Thomas Houston Associates have seen an upsurge in requests for pay equity products. Whether it be due to the hashtag movement or the variations in the Department of Labor's Office of Federal Contract Compliance compensation approaches, or due to the relative inaction of the Congress and states to take the lead, or the private sector's engagement in which CEOs are encouraging other employers to conduct their own pay equity analyses, we have seen a groundswell of interest in this area. But again, there is no one common definition or approach to pay equity. Since there is no common definition of pay equity, interest groups and employers are able to define it as they see fit. Here, the American Association of University Women, or AAUW, is comparing the average wage differential by women in racial subgroups compared to white, non-Hispanic males working full-time over the age of 16. This data is captured by the U.S. Department of Labor on an annual basis for all employees working full-time over the age of 16. You might be asking yourself, how would I proceed with a pay equity analysis? Here at Thomas Houston Associates, we recommend that if you're going to conduct a pay equity analysis, you identify a small, discrete internal team. You decide from the onset what is going to be reported and to whom, and have a commitment that if there are individual salaries that require an adjustment, that there be a commitment that those adjustments will be made. We recommend that the analyses be conducted under attorney-client privilege at the direction of counsel, and that the scope, the timing, and the budget all be discussed. Lastly, we recommend that there be a decision on what would be an acceptable difference in pay in compensation. I discussed earlier looking at titles in which there was a 2 standard deviation difference in pay, but it could be that your internal team wants to look at a dollar threshold or a percentage threshold difference as well, in order to make sure that all salaries are being reviewed, not just those that flag statistically. This is but one example of who might comprise your internal audit team. It is critical that someone from compensation, knowledgeable about all of the types of remuneration and how each system works, is part of the team. It's important that counsel be involved to establish attorney-client privilege. The EEO or affirmative action person plays a critical role because they know the compliance mandates. Someone from staffing or talent acquisition could be critical, especially where there's a lot of hiring, as they might add value to the onboarding process and how initial salaries are set. And select others from HR or management might fill out your small internal working group or pay equity team. It also might be important from the onset to determine what your thresholds will be for acceptability. By this I mean, if you're going to allow there to be policy deviations in which there are individuals who benefited from inconsistent use of the compensation tools, how often will you allow that to be permitted before it's questionable altogether? The more policy deviations there are, the less likely a legal authority will think that there's actually a system underlying it if all the one-offs begin to outweigh the system itself. Now that you have your internal pay equity audit team, the budget, reporting relationships, and that the work is going to be performed at the direction of counsel, therefore under attorney-client privilege, you should focus on your pay equity analysis. Remember, there are standards and thresholds for the Equal Pay Act and ensuring non-discrimination in compensation, but there is no one definition of pay equity. While some employers in the private sector leading the charge, encouraging others to conduct pay equity analyses, have stated they have performed regression analyses as a form of pay equity analyses, there's no one standard regression analyses either. And after performing the regression analysis and changing individual salaries, they may not have identified the underlying root cause that has caused these compensation issues. Thereby, the same issues may surface the following year and other successive years as well. Now that you have your internal pay equity audit team, the budget, reporting relationships, and that the work is going to be performed at the direction of counsel, therefore under attorney-client privilege, you should focus on your pay equity analysis. Remember, there are standards and thresholds for the Equal Pay Act and ensuring non-discrimination in compensation, but there is no one definition of pay equity. While some employers in the private sector leading the charge, encouraging others to conduct pay equity analyses, have stated they have performed regression analyses as a form of pay equity analyses, there's no one standard regression analyses either. And after performing the regression analysis and changing individual salaries, they may not have identified the underlying root cause that has caused these compensation issues. Thereby, the same issues may surface the following year and other successive years as well. A regression analysis is a statistical technique that allows an employer to assess how race or gender affects a dependent variable, in this case, pay. When controlling for factors that might influence such, using a multiple regression analysis, one employer might be able to show how seniority and educational attainment have a direct correlation on pay, with those with higher educational attainment and more time with the employer having higher salaries, regardless of gender or race. Another employer, even when every possible variable is included in the analysis, may have pay differentials remaining, affecting a racial subgroup or gender. If you are going to perform a regression analysis, we encourage you to expand your internal pay equity team to include a professional, a statistician, for example, or an industrial psychologist, who will not only help you develop the model appropriately, but also can defend it in litigation. In litigation or an enforcement action, the discussion and debate often centers on the regression model itself and its analysis, with lawyers and investigators sidelined, as the statisticians take the lead. What variables should be included? Which one should not be included? What's the proper analysis? Can all be contested. Simply alleging that legitimate factors exist that might explain away salary differences does not suffice in a court of law. If cases go to court, a judge might determine the validity of the factors utilized and the actual type of analyses conducted. One term that is often referenced when disputing regression analyses is as a variable having been tainted by an employer. A tainted variable is one within the employer's span of control and therefore can be deemed contaminated by an employer's discriminatory actions. Thomas Houston Associates now offers a variety of pay equity analyses. We've already discussed the base pay analyses by title, where average base pay between men and women, minorities and non-minorities is highlighted if it's statistically significant. I've also discussed the new product, which is similar but identifies those titles that have an average wage differential across the entire company that is statistically significant, warranting closer attention. This saves mid and large employers a lot of time by not having to cull through each base pay report by location. This base pay report could be produced using another threshold as well. For example, an employer might want titles highlighted that have not only a statistically significant average differential, but have a certain dollar value or percentage difference, say 5, 10, or 15% differential between men and women and minorities and non-minorities. THA can create a pay equity report using a different differential as well, or using a different form of compensation, perhaps W-2 wages. For those who are federal contractors, reviewing the type of compensation that's required during a compliance audit by the OFCCP is critical. We call this Total Cash Comp OFCCP approach. In this approach, we would run an analysis in which we aggregate base pay, merit increases, bonuses, incentives, commissions, and overtime as required submitted to the Department of Labor during an audit. This report can also be run using a different type of total cash compensation that's employer specific, which might include sign-on bonuses and retention bonuses and other forms of compensation. We can perform a state-specific analysis, especially for those states that have stepped out into a more rigorous Equal Pay Act. We'll discuss that a little later in this presentation. And there's a bevy of other analyses that we can perform under the rubric Pay Equity Analyses. For those employers who have a large number of individual contributors, by that I mean job titles in which there's only one employee and no one for comparative purposes, you might want to consider reviewing base pay by a larger cohort, such as salary grades, or the 10 EEO1 classifications, which you must report the demographics of your workforce to the EEOC on an annual basis. This is an example of a review by the 10 EEO1 categories with the race and gender groups that have a statistically significant differential highlighted in yellow. This is yet another approach to a pay equity analysis that some employers may wish to consider. As mentioned earlier, whether it is due to the groundswell of interest in pay equity or the relative inaction of the U.S. Congress, several states are strengthening their Equal Pay Acts. This chart represents how strong the AAUW feels state Equal Pay Acts are with regard to gender. Though all states are covered by the Federal Equal Pay Act, as of this writing, only one state remains without a state Equal Pay Act, and that is Mississippi. The majority of state laws mirror the Federal Equal Pay Act, but some are strengthening their Equal Pay Acts as we speak. New York is one such example. In the state of New York, along with other changes, the definition of similarly situated is broader now than just at a specific establishment, and now may be as large as a county. This is an example of a pay equity product produced by Thomas Houston Associates for New York State. In the example here, we have the borough of Queens, which, while it's a borough, would also serve as a county in New York State. The title are Customer Advisor 1s, and these individuals are located in many establishments throughout the county of Queens. At each individual location, there may not have been other Customer Advisor 1s, or too few to be statistically significant, or may not have had a pay concern. But when aggregated to a group, we now have more than 25 employees in the title Customer Advisor 1, and we see there to be a statistically significant average pay differential larger than 1.95 standard deviations affecting females. Some employers are supplementing their broad overview of compensation to include current decision-making at this point in time. Thomas Houston Associates has seen an uptick in employers requesting a performance rating or a performance rating merit review for this year's decision-making. A simple performance rating analysis might be ensuring that all performance ratings fall within the performance rating distribution guidelines. A merit review analysis might be as simple as ensuring that guidelines are adhered to, in this case, that those who were rated exceeds received a 2 to 4% increase, and those who received a meets received a 0 to 3% increase. In a more sophisticated salary grade matrix, we might review to ensure that merit increases fall within the guidelines for where that individual is within the range, whether they be above or below the central tendency of the compa ratio or the range penetration mark. While there are lawful rationales for pay differences between men and women, minorities, non-minorities, and racial subgroups, such pay differentials can also be due to biases, stereotypes, job assignments, exceptions to pay guidelines, and starting salary differentials, all of which can lead to disparate pay. What works best for you at this time is going to vary with each employer. The options cover the gamut, from oversight of base pay, this year's annual bonuses, perhaps even total cash compensation. For those of you who are looking at this year's decision making, whether it be performance ratings, merit increases, bonus increases, promotional increases, Thomas Houston Associates can produce a report for each one of these facets. There's a wide variety of options, and we're willing to work with you to develop what works for you best at this time. What works best for you at this time is going to vary with each employer. The options cover the gamut, from oversight of base pay, this year's annual bonuses, perhaps even total cash compensation. For those of you who are looking at this year's decision making, whether it be performance ratings, merit increases, bonus increases, promotional increases, Thomas Houston Associates can produce a report for each one of these facets. There's a wide variety of options, and we're willing to work with you to develop what works for you best at this time. This concludes the presentation on equal pay, ensuring non-discrimination in compensation, and pay equity analyses. Thomas Houston Associates has a rich history in this area and is a proven leader in understanding compensation systems. We have flexibility in our pay equity reporting and are willing to work with employers to develop a product that works for each. Thomas Houston Associates expressly does not provide legal advice and requests that counsel be consulted for any legal opinions or matters of this nature. If you'd like to learn more about any of the topics covered in this short video, please consult either your Thomas Houston Associates project manager or Mary Franzak, President of Thomas Houston Associates, at the number and email on this screen. Thank you for your time.